Good afternoon, everyone, and welcome to this webinar. This is going to be a follow-up to some questions that apparently were left unanswered, or maybe some questions that simply arose since our firm seminar on March 3rd under the presentation that I made entitled Termination of Employment, the Ohio Revised Code, Section 4123.90, and other employment laws. Our format today is going to be that I'm going to answer the questions that have been submitted to us. We have a total of 9. And we will spend whatever time is necessary to get through those. If it's 15 minutes, then it'll be 15 minutes. And if it's 45 minutes, it'll be 45 minutes. For once, I will not be shut down by running out of time. Helping me today is Carrie Ramirez of our firm's marketing and IT coordinator. And so, Carrie, let's begin. What's our first question?
If I have someone that started working here through an employment service on January 1st, 2016, and were hired on our payroll effective April 1st, 2016, assuming they work 1,250 hours and are employed at a location with 50 plus people, when are they eligible for FMLA with our company? January 1st, 2017 or April 1st, 2017?
Well, Carrie, I'm going to assume and give a short answer that the 1,250 hours worked have been worked by January 1, 2017. And if that's true, then January 1, 2017 is the date. Even though they've only been on your payroll for 9 months, they've been employed by you for the 12 months. And why is that? The Family and Medical Leave Act is actually a part of the Fair Labor Standard Act, and it defines employ in the broadest possible terms as suffer or permit to work. This raises a caution for some of you out there. When you use temps, if you are near the 50 employee barrier on your own count, be cautious because temps are included in the count when determining whether the FMLA applies to your site. For example, let's assume that you have 40 regular payroll employees and you have an additional 15 temps. Maybe they're working to cover vacations. Maybe they're working in some of the less desirable jobs. What they are doing doesn't matter. They are there. They are on your payroll, on your site, pardon me. They are on your site. And along with the 40, you have, for FMLA, 55 employees. So the FMLA applies. If that applies to you, be careful. You might even want to give us a call to talk through it. Carrie, what's our next question?
How do we handle a situation where an employee has requested FMLA and been given the required paperwork for their doctor to complete, but has yet to return anything? I have an employee approach me in December and stated she was pregnant, due in July. She was given the paperwork and told to return it within a week of receiving it. I have asked her weekly about it, but continue to be told that she has either lost the paperwork or is waiting for her doctor to complete this. What is my responsibility in this case?
Well, this is an interesting question. I would say, first off, that we need to recognize that you, under this circumstance, can deny or delay or deny the request until the employee has provided the necessary certification provided. And that provided is that when you asked for it, you warned her of the possibility of the leave being delayed or denied if she failed to get the certificate back to you. The citation to the Code of Federal Regulations is shown there on the screen if you'd like to check that. There is a caution here, and that is that even though the employee might be delinquent or late, what happens when the employee suddenly gets on time and does present the certification? The FMLA provides that the leave will then begin once an adequate certification has been provided. So my suggestion to you is that you should keep hounding this employee, even though you're not required to. It probably makes good sense to do so, even to the point of offering to fax the certification form directly to her doctor. Remember, by definition, pregnancy is a serious health condition, and so you know that this employee has a set of circumstances that qualify her for an FMLA. Keep hounding her for the completion of the paperwork. Carrie, what's our next question?
For a person on FMLA over a holiday, but we require them to use paid sick vacation time until exhausted, do we pay them vacation time or holiday time for the holiday itself? People who are not on FMLA but took vacation before and after the holiday, for a period including the holiday, were paid holiday time, not charged vacation for the holiday itself.
Okay, this question asks actually a question about benefits of employment other than health insurance. And the general principle of the FMLA is that such benefits other than health insurance, are during an FMLA leave, are governed by the employer's pre-existing policies that must be applied on a non-discriminatory basis. This is essentially a discrimination question. In your fact pattern, you said that other employees on vacation time were paid for the vacation time, were paid for the holiday, but it was not charged to their vacation time. Therefore, under these circumstances, the correct answer for your situation is to pay the holiday pay, but do not count it under your sick or vacation policy. Carrie, what's our next question?
Requiring specific hours, time off, i.e. vacation or personal, to be used during FMLA, Department of Labor states employer may require this. How to explain to employees grievances in regard to the policy?
Well, this is an interesting how-to question. It is not addressed by the FMLA. It's a personnel relations question. How do you deal with your employees? You know them way better than we do. So my suggestion, which is about to be made, may fall on deaf ears or not make sense in your situation. However, one of the things that an employer might be interested to know and might be helpful in answering this question is that the employer's right to require this is the same thing as maybe the employer's counterpart as the employee's right to demand it, consistent with the employer's normal leave policies. And what I mean by that is that the FMLA regulations specifically say that if the employee wants to use available paid time off in conjunction with the FMLA, he or she may do so. What's our next question?
Do you have to offer FMLA to those with a health condition or wait for the employee to approach you on this? If an employee calls off for 3 days in a row due to a medical issue, are we required to automatically address it as an FMLA issue?
Well, you are not required to track down employees and keep track of every sniffly nose and absence here and ask if they want to use FMLA. You do not have to track them down. We can get into a different question as to once you are on notice that they may have a qualifying reason, what your obligations are then. But here the question is, do you have to track them down and keep asking? And the answer is no, you don't. Let me ask you another question, though, as a follow-up, longer with maybe a better answer. If you have the chance to use up some or most, maybe even all, of the 12 weeks of FMLA leave, why would you not want to do that? We did discuss that briefly at the seminar. Basically, there's a reason why you would want to do that and a reason why not. The reason why you would want to do that is that you use up the 12-week allotment. The purpose of doing that is that until that allotment is used up, the employee has return to work rights. Same job, same shift, same benefits. It's a fairly strong set of rights that the employee has, so long as there is some balance remaining in their FMLA allotment. Given the opportunity to use up that allotment, I think you would want to. Now, there is a reason not to do that, and that is this. If it is an FMLA leave, then health insurance must be continued. Whatever health insurance you're providing must be continued, and that happens even if the employee fails to pay their portion of the premium during the FMLA leave. There is a provision for the recovery of unpaid premiums if that's what happens, but I think as a practical matter, if you're left with a small claims court suit against your employee for unpaid health insurance premiums over the time they were on FMLA, you understand that that's not an option that you want to pursue. So if you have the chance to use FMLA, I think you're better advised if you do. Now, there's one last item that I want to mention in this question before we go on to the next one, and that is that in the question, the facts assumed that there were 3 days in a row off due to a medical issue. That's fine. That's wonderful. That, however, is not, in and of itself, a serious health condition. The regulations define serious health condition as more than 3 consecutive calendar days. So while this particular employee is right on the verge, right on the edge of qualifying as a serious health condition because of their consecutive days off, they're going to need one more consecutive day off to get to more than 3. Carrie, what's next?
For exempt employees, can they be required to take sick or vacation time for any absence, even if only part of a day or less than a whole day? Does it make a difference if it is personal or sick?
Well, a tip of the hat to whoever asked this question, because this is going to be a topic of great depth that we're only going to brush up against slightly. But said another way, the question here is, how can I reduce the pay of an exempt employee who is absent? To set the table just a little bit, every exempt employee, and what we mean by exempt is they are not entitled to overtime when they work more than 40 hours. Exempt employees must meet 2 tests. One is known as the primary duty test, and that has to do with whether they are an executive or a professional or an administrative position. But the second test, a test that is often forgotten, is that they must be paid on a salary basis. And when you start reducing pay for absences during the week, you run into some real difficult issues to maintain the idea of passing the salary basis test. There is a general rule to follow, however, and it is this. You can reduce the pay of an exempt employee without losing the salary basis if you're doing it for the absence of a full day, not partial days, full days, and the absence is for personal reasons other than illness or disability. So if somebody is ill today and is out all day long, although it is a full day, it's because of illness, so the pay cannot be reduced. On the other hand, if somebody decides, this is a beautiful afternoon, I think I'll go golfing, and they work from their normal start time, say 8:30 till 10:30, and then they want to make certain that they make their noon tea time, they leave and are gone the rest of the day, you cannot reduce the salary either because it was not a full day's absence. Partial days, and for reasons other than illness or disability, are the guidepost. Now, there are some exceptions to this that I think we would mention. There is no pay if the employee is absent for a complete week, even if the reason for the absence is illness or disability. And I think you can see how that starts to lead into an FMLA type of consideration. An employee off full weeks, maybe 3 or 4 full weeks because of an FMLA, serious health condition, would fit into this exception, and there could be no pay provided to them without jeopardizing their exempt status. The second exception is if you, as the employer, have a pre-existing policy or practice that compensates for what kind of days? Full days missed because of illness or injury. For lack of a better term, do you have a sick day policy? Do you have a sick day policy? And to the extent that you compensate for full days missed due to illness or disability, you can reduce the salary and then make up the missed salary by using up one of the sick days under your policy. There are 2 situations where this can be, you might say, look, the pay is still the same. Well, that's true. The pay is the same, but the employee's benefit chart, if I can say that, has changed. They now have some number of fewer sick days than they had before. This is true. Then there are 2 circumstances where this comes into play that you may not be aware of. The first one is, what happens if this employee has already used up all of the available time that your sick pay policy provides? Let's say you give 10 sick days a year, 5 sick days a year. You give a finite number of sick days a year. And in this particular circumstance, the employee has used those days up already. You can still deduct the pay for the full day absence because of the existence of the policy, even though the employee at the moment has no benefits remaining. By that same principle, a new employee, someone who perhaps has not been in your employ long enough to qualify for this plan, has no days available to them because they don't yet meet your qualification standards. You can still deny the pay for them. The final exception, of course, deals with the FMLA. There's a very specific regulation that says an absence covered by the FMLA for an exempt employee can be unpaid under what's known as the rule of proportionality. A very simple explanation of what the rule of proportionality is would be this. Consider an exempt employee whose normal work week is 45 hours. During the course of that week, maybe they go to rehabilitation, maybe they go to a doctor's appointment. However it adds up, over the intermittency of that week, they are absent for FMLA reasons for 9 hours. 9 hours is 20% of their normal work week. You may reduce their compensation that week by 20%. That is a little known rule of the FMLA, and most employers hesitate to do it. I'm not telling you whether you should or you shouldn't. I'm telling you it's out there. And if you do it, the FMLA regulations will cover it so long as you've met the rule of proportionality. Carrie, what's next?
Is post-traumatic stress disorder considered a disability under the ADA?
Let's remember that a disability is not just a physical impairment. It includes, by definition, a mental impairment that substantially limits one or more major life activities. As you all know, some 7 years ago now, the ADA was amended, and in large part, what it did was loosen the definition of what constitutes a disability. And it also included a list of specific conditions that were recognized as a matter of law to be disabilities. And post-traumatic stress disorder is one of those specifically listed impairments under the regulations. So yes, PTSD, post-traumatic stress disorder, is a disability under the ADA. Carrie, what's next?
If it is not written in our policies, when is it appropriate to terminate employment once FMLA expires and there is no ADA protection?
May I say that I'm concerned I may have misinterpreted this question, but I would say that if it is not written in your policies, I presume that it that is not written is the reason that you want to discharge somebody. Well, let's start with what I'm sure you've all heard, probably to the point that you're sick of hearing it. Ohio is an employment at will state. And stated as it was originally crafted almost 150 years ago now, employment at will simply means when I decide that I don't want to work for you anymore, or when you decide that you don't want me to work for you anymore, that's the end of it. It is our will, or it is the will of any one of us, to end the relationship, and that's that. Nothing further said. Now, while that's the general rule, in reality, in practicality, that's not the rule at all. Ohio is not an employment at will state because there are so many exceptions to the rule. It's employment at will unless the employer has induced the employee into a position of detriment such that if the employee were to act on the employer promise, they would be harmed. It's employment at will, except you can't discharge a person because of their gender, because of their race, because of their age if they're over 40. There are so many exceptions. My personal opinion is that Ohio is not an employment at will state any longer. Now, with that said, let's try to answer your question. And I would say to you, be very careful. If I've interpreted your question correctly, be very careful before disciplining or terminating someone for a reason that has not been expressed in your policies. If you don't have a handbook, or if you have an out-of-date handbook, if we were in a seminar room, I'd ask how many of you thought your handbook was up to date, and if anybody raised their hand, I'd say, no, it's not. But let's continue that if you have an up-to-date handbook, you will find sufficient reason somewhere in there to cover every situation. Now, even some situations that in the past have proven to be lawful, we now have a very active National Labor Relations Board that is intruding itself into the relationship of the non-union employer and employee, as well as which it has done historically, as well as the relationship of the union employer. It seems that on about a every month basis, one or more decisions come out of the labor board saying that this particular employment policy, which we've seen for ages, could discourage employees in the exercise of rights under federal law. Confidentiality policies, policies about taking photographs or videos in the workplace, what you post on your social media site concerning that so-and-so who's your boss. Those are just a few of the examples. So be very careful if you're going to discipline somebody for a reason not already expressed in your policies. And may I say that probably the best thing to do is to call us first. Very careful here. Carrie, what's next?
How could Florence get fired for excessive methadone use? If she had a prescription, the MRO should have released the test as negative, period.
I think this comes from the fact pattern where we indicated that Flo had been fired because of the results of the drug test. What we may not have made clear is that the drug test that she took was one taken at the hospital and as part of the treatment of her injuries. I absolutely agree with the person who asked the question that if this was a test conducted pursuant to a drug test policy, maybe it was a random test, maybe it was a for cause test, maybe it was a pre-employment test, whatever it was, but if it was a test result, if it was a test administered under a policy, absolutely agree that the MRO would first speak with the test subject, in this case Flo, to see if there was a reason for a positive test. And ultimately, under the facts given that she was under a prescription, would report back to the employer a negative result. However, our fact pattern had a different reason for the taking of the test. And so the first thing that we have to do here in terms of appropriate discipline, if any, is to determine what was the basis for the test in the first place. If it's a positive drug test, we're going to let it be just as the questioner asked. However, we also had a rule that prohibited employees, and I believe all of you, or certainly most of you, have a rule that prohibits an employee working while under the influence of a drug. Now, I know that different substances require different levels of concentration before it's fair to say that an employee is working under the influence of that substance. But that is the rule that caused Flo to be disciplined. She was working under the influence. She was driving on the public roads under the influence. Whether she had a prescription from her doctor or not does not protect her from violating the working while under the influence rule. We have no further questions. I appreciate each of you taking time to sign on and listen in today. If you have any questions that are still unanswered, please feel free to email them to us, and we'll do our level best to try to answer them. Thank you very much.